page 4 is where we left off, so we'll finish that one page. It had to do with clinical research. And if you need a hard copy of that, there are just a couple left up here on the table. You're welcome to come and get one. So at the top of the page, it talks about HIPAA provisions as related to clinical research. And it points out that the identity of any and all volunteers has to be held as strictly confidential. So that means that in any reports, any research reports or reports of data from these clinical trials, any names of patients have to, or volunteers for that matter, have to be de-identified by the use of codes. So generally codes are used in any of the data collection rather than the actual names of the subjects who are involved in these studies. In terms of where it says good clinical practices in investigational drug research, the comments we can make about that are, first of all, that formal training is required for all personnel in these studies. Some sort of formal training for all the personnel involved in these studies is required. Also, the FDA has the right to inspect the facilities where these trials are conducted. I mentioned to you last time that many of the clinical trials now are done by organizations referred to as CROs, clinical research organizations. The company based, I think, in New Jersey called Covance is one big example of that, but there are many of them, and the FDA would have the right to inspect any sites, or could be sites in hospitals or industry or wherever. And the final point about this good clinical practice is that the IRB members, the members of the Institution Review Board, also have the right to request to inspect the sites and actually to observe the studies, to observe the trials as they're being conducted. The next bullet item says reporting adverse drug events during clinical trials. So what are the issues there about reporting adverse events that occur during these research investigational drug trials? Well, first of all, the FDA requires now the full disclosure of results, both positive and negative. In the past, there were situations where the companies didn't report some of the negative effects that sort of disproved their points or raised issues. But this has to be reported fully now. But it can be done in a way that will try to protect the competitive interests of the company. So the reporting can be reported in such a way that it doesn't reveal exactly what the drugs are that the company's working with, because obviously there are competitive issues involved, patent protection and all that. But the FDA requires that eventually full disclosure will occur. So they would be allowed to delay the full disclosure in the interest of competitive advantage and disadvantage. Another point regarding the reporting of the adverse drug events is that when these events are reported, the degree of severity has to be indicated, the degree of severity. For example, was the patient hospitalized? Was it necessary to hospitalize the patient? Or was it necessary for the patient to withdraw from the study as a result of the adverse effect, to withdraw from the study? Or, you know, in the worst case, of course, did the patient die as a result of the adverse effect? That would all have to be specified. Also, there are some differences in how the reporting would be done depending on whether the drug being investigated was one that was already approved on the market, or, as would be the case in most situations, where it was not yet approved on the market and was really an investigational drug. The next item talks about pediatric investigational drug research, some of the ethical issues involved there. And the FDA, not surprisingly, is very protective of children. So it's more difficult to conduct clinical research, clinical trials, using pediatric patients. And as a result of that, there are fewer drugs for which full safety and efficacy has been proven for use in pediatric patients, because it is more difficult to conduct these studies. And as a result of that, if you observe package inserts, there's a lot of package inserts that will say that the use of this drug is limited, or it's not approved, not approved for children of pediatric ages. Even though you'll notice that physicians and pediatricians actually prescribe these drugs for pediatric patients, even though it says not approved for that. And the reason for that is that they haven't really done full safety and efficacy studies on pediatric patients because, as I said, it's more difficult to do these studies. And as a result of that, the doses for pediatric patients of drugs that we know the doses, what the doses are in adults, the doses in pediatric patients are really more of an estimate. And as you, if you check in various pharmacy math books and so forth, you'll see a lot of formulas that they give you to estimate, based on the adult dose, what the pediatric dose would be. These are purely estimates, and you know, the results can be quite unsuitable depending on the drug. As a result of this, they've used the term sometimes for pediatric patients as calling them therapeutic orphans. Therapeutic orphans meaning that, you know, we really don't have hard data for many of the drugs used in children. And of course, the reason that they state this in the package inserts is for liability reasons, since it hasn't been fully approved by the FDA. It's one of the difficulties in conducting clinical trials with pediatric patients is that parents sometimes are very reluctant to consent to have their children involved in these studies unless the child really has a life-threatening disease for which, you know, there's not many choices other than trying some new investigational drug. Then it might be easier to get the parents' approval, but it's hard to get that because, you know, parents, especially those who don't fully understand the nature of these studies, feel that you're using my child as, you know, a guinea pig and that sort of thing. So it's hard to get parental consent a lot of times. It's interesting to note that in 1997, the FDA passed legislation referred to as the FDA Modernization Act, the FDA Modernization Act of 1997. And in that act, they provided certain incentives to companies to encourage more pediatric trials, more pediatric drug trials. For example, they would give companies a 6-month extension on their patent life, which, you know, can be significant in terms of the financial benefit of a 6-month patent extension, things like that. And in some cases, the FDA has actually mandated that clinical trials be done in pediatric patients because it's necessary to have that information. One other deficiency in terms of pediatric drug availability is that a lot of times there are not liquid formulations of drugs that are used in pediatrics commercially available. There's only pill forms and not liquid forms. So as a result of that, people turn to compounding pharmacies to prepare liquid formulations and flavored formulations and so forth of these drugs. And of course that adds to the cost, but maybe the only alternative. At the bottom, it has the important bullet item then of compassionate use of investigational drugs. Compassionate use of investigational drugs. And this term also more recently is going by terms such as right to try. And there's legislative efforts referred to as right to try, implying that people have a right to try drugs under certain circumstances that are still investigational, even if they're not part of a, you know, phase 2 or phase 3 clinical trial. That, you know, if there's a terminally ill patient where there's no hope and there's no really good drug, and this investigational drug shows some promise, giving that individual the right to try that drug, even though they're not formally enrolled as part of a phase 2 or 3, usually clinical trial. This is also referred to as expanded patient access. These proposed rules and legislation referred to as expanded patient access. And this approach is reserved, pretty much reserved for terminal or seriously ill patients, either terminal or seriously ill patients, you know, who are have life-threatening diseases, where there is no comparable satisfactory available drug. It's approved, no comparable satisfactory drug. The drugs that are used for this so-called compassionate use or expanded access have to be in phase 2 or 3 clinical trials. Otherwise, it wouldn't be allowed. They have to already be in phase 2 or 3 clinical trials. And it turns out that the FDA has to be formally involved in approving the use of these drugs for this purpose. So the key is that there has to be an application made, actually by the patient's physician. So the patient's physician is a key player in this. The application has to be made by the physician to the FDA, and the FDA has to give approval. And the company that's sponsoring the drug, the company that's sponsoring the investigational studies for the drug, they have to be on board with this too. So those are the important players. 38 states have laws about access to these investigational drugs outside of clinical trials. 38 states. And federal legislation is also being proposed currently to have a federal law, going through the FDA, I suppose, to indicate this. And in fact, one of the people who is supporting this and supporting this kind of a development at the federal level is Vice President Pence. This proposed federal legislation would, interestingly, would protect manufacturers. This is one of the concerns manufacturers have about using the drugs in this way. This legislation at the federal level would protect manufacturers from any liability that would cause the FDA, for example, to use negative results from this kind of study, from this kind of treatment, this out of investigational trial treatment, to use any of the negative results of that as an excuse or a reason not to approve the NDA. So the federal legislation would say, this is compassionate use. You can't use the results of this to either prove or disprove the value of your drug being approved by the FDA ultimately. That should be based on the actual patients that are formally enrolled in phase 2 and phase 3 clinical trials. So the FDA approval is key to this, and they have to also show as part of the application that this is not going to put the patients at undue risk. Now, they should not put them at undue risk, even though it's reserved for terminal situations. Also, it's possible to have some payment given to the company to cover the costs of the supplies. But the goal of that is not that the company would use this for profit. It would just really be to cover the cost of supplies. And in most cases, I would say the companies don't even get into that. They pretty much provide it pro bono. Finally, at the bottom it talks about off-label use of prescription drugs. And it says, in order for the prescribing and dispensing of off-label drugs to be ethical, it must be based on peer-reviewed publications, and there should be a conviction based on collective experience that the off-label use will be safe and effective. Now, as you know, the FDA has a very strict prohibition on companies actively promoting off-label uses, and some companies have had very substantial fines levied against them for being accused of actively promoting these off-label uses. But interestingly, in 2012, there was one company that successfully challenged the FDA's prohibition of, quote, promoting, whatever their definition of promoting was, these drugs. The company indicated that they were providing information to physicians about their drug for off-label use, and what the information they were given to the physicians was truthful. They could show that it was truthful. It wasn't fabricated or speculated information. And so on the basis of First Amendment freedom of speech rights, one court, I think it was in New York State, ruled in favor of the company, and the FDA sort of had to back down in that. So some people thought that this was going to lead to kind of a weakening of the FDA's strong prohibition on active promotion of these drugs, but so far there hasn't been any real evidence of that, and I think companies are, not in the mood to try to go to war with the FDA or test them in that. But it is interesting. If the information is truthful and you prove that, it gives you a little more leverage in providing information about off-label uses. So with that, let's go to the outline the new outline that was given out that talks about ethics of pharmacist-patient communication and evolving legal trends. And I know you've had a lot of courses in dealing with communications and so forth, so let's just sort of think about some of the ethical aspects of this. So it says the benefits and value associated with effective patient communication, it's ethically appropriate. It's ethically appropriate based on values that we've talked about a lot already. It's ethically appropriate based on veracity, for example, beneficence and non-maleficence, all of those reasons, and patient autonomy. Patient autonomy is especially applicable, I would say, for the ethical justification of strong communications. It's also good business because it builds trust and loyalty with the patient. It encourages patients to use a single pharmacy so that the pharmacist really has a good way to evaluate progress of the patient and to detect non-adherence. It also, effective communication reduces the chance, or at least the severity, of medication errors. And finally, it's felt that strong communication with patients, effective, leads to better pharmacist job satisfaction. Because the patient's happy, it makes the pharmacist happy. Media and public scrutiny of inadequacies in pharmacist communication with patients. There have been sting operations, I guess you would call them, that have been done that really show the virtual absence of counseling in some pharmacies. And in some cases, this has become promoted in the media to show that, that despite what pharmacists claim, you can go to pharmacies and there's no effort to counsel. And of course, the recent Chicago Tribune sting operation that we talked about, where a very high percentage of pharmacists, and depending on what pharmacies we were talking about, failed to identify significant drug-drug interactions. Those are examples of that. So full disclosure and informed is required for informed consent or refusal, as we've discussed. And then it talks about evolving and changing standards and expectations. So in the current code of ethics that we presented to you the other day, in that current code of ethics, it points out that it's one of the clear ethical mandates for pharmacists is to obtain optimal benefits from medications, that patients will obtain optimal benefits from their medication, and also that patients will be able to exercise autonomy in their decisions to use or to not use medications. And obviously communication is essential for that, and it's essential that the pharmacist goes to some effort to determine that the patient really understands the information that's been presented to them. And you're familiar with the teach-back methods and things like that. It then says more is not always better, and the Code of Ethics, if you remember, says that we should communicate in terms that are understandable. The code says that, communicate in terms that are understandable. So that implies that we don't overwhelm the patient with more information that they can handle. And that's why I say, sometimes more is not always better. And obviously that you don't use technical terms. I think we mentioned the other day that in a lot of hospitals now, when they conduct their exit discharge counseling of patients on the meds that they're leaving the hospital with, they limit the mention of an ADR to just one item, even though there may be other items that you would think about talking about. And again, this is part of this effort that more is not always better. And timing matters. That means that there are certain times when a patient simply is not in a mood or in an appropriate frame of mind to benefit from information that's provided to them. So, if you're in a pharmacy, you want to counsel a patient, and the patient is obviously in a big rush, or they're very ill, or, they have a kid in the car that they've got to get back to right away, then that's not a good time to try to talk to them about their medication, but you can offer to talk to them by phone at a later date or another time, a good thing to do. So in other words, the patient needs to be psychologically prepared to listen and to understand, especially if the information is going to be detailed. And for example, very often the doctor's office is not a a good place where the patient is predisposed to really benefit from the information that the doctor is usually in a hurried fashion telling them. So that's why it's all the more important for pharmacists to try to augment what the doctor may have told the patient. Even the time of being discharged with your meds from a hospital may not be such an ideal time, because people are very concerned about, you know, getting out of the hospital and, you know, how they're going to handle themselves on the outside and all that. So sometimes you have to find better times to do these things. And of course, this timing matters also applies to the psychological state of the pharmacist too. If the pharmacist is under tremendous pressure, where there's a big line of people waiting to get their prescriptions and you don't have enough help and all that, maybe that would be a good time to say, I really need to talk to you about this, but can I arrange a time when we can talk over the phone? So then it says, from an ethical perspective, just how far do pharmacists need to go in disclosure of potential information? And I'll let you read that paragraph on your own. But basically, what this sort of says is that if an ADR is really seriously life-threatening, even though it occurs rarely, maybe you should mention that. That's a possibility to mention it. Then for ADRs that are not life-threatening but are troublesome, but occur to a large extent, like clearly over 10% or over 15%, maybe you should mention that too. So that would be a guideline. But I think the fact that we mentioned it in a lot of hospitals now, they're limiting just to one ADR, might be good advice as well. Maybe you pick out the one that's the most significant and emphasize that. And the idea of going through a whole list of all the things and some of the things mentioned in the package insert, even if they are, you know, life-threatening and or occurring frequently, may not always be the best idea. So you have to use a lot of judgment in that regard, some of your professional judgment in that regard. It then says, have legal standards kept pace with the changes in professional ethical standards in pharmacy since the 1980s? The general trend observation, and this trend is gradual, and is with all court decisions it's mixed, but it is discernible. And that is that court decisions about pharmacists' expanded duties beyond just getting the right number of pills in the bottle and the right drug off the shelf. Our expanded duties are the decisions in that regard, while still variable, are trending in the direction of our having more of an expanded duty. The court decisions are trending in the direction of recognizing that pharmacists have an expanded duty for what we would call patient care roles. And of course, our code of ethics clearly indicates that we have those expanded duties, and as you know, that code of ethics could be a subject of something that's going to be brought up in a court case as evidence. Over 90 legislation required counseling. Initially, the over 90 legislation required counseling with all new prescriptions for Medicare and Medicaid drugs. That was the over 90 legislation. But the states, all of the state boards, quickly said that, well, this is going to apply to all prescriptions, not just Medicare and Medicaid prescriptions. But depending on the state, and the state requirements are variable, in most states, I would say, rather than saying you must provide counseling, it's come to that you have to offer to provide counseling. And that offer can be really made by a clerk or by a pharmacy technician or whoever. And if the patient wants counseling, then the pharmacist has to carry it out. And that counseling can be done one-on-one, or it can be done it can be done face-to-face, like in the pharmacy face-to-face, or it can be done one-on-one over the telephone. And a lot of the mail-order pharmacies get by with that by, in the information they send out with their medication. They say, you're welcome to call 24 hours a day, toll-free line and all that for the pharmacist. And so that would be the one-on-one counseling. P&T committee formulary systems exist not only in hospitals, they have always existed, for a very long time have existed in hospitals, but also Medicare Part D providers have to have a formulary system in place, and most of the PBMs and health insurance companies also have formulary committees available. And there are ethical obligations for pharmacists who normally play a key role in these P&T committees. So particularly in hospitals, you wouldn't have a P&T committee without pharmacists being on it, and I think that's true in the other venues as well. What are the ethical principles involved in serving on a P&T committee? Well, I think veracity would come right front and center, veracity of the information. Also, beneficence, non-maleficence concerning the patient. You know, what is going to be of benefit and certainly if not harm, do no harm to the patient. Autonomy is also another important ethical issue that comes into play in these P&T committees. Autonomy of the prescribers, primarily of the prescribers. And then finally, distributive justice. Distributive justice, because part of the decisions in P&T decisions is to not make the costs of the medications so onerous that it compromises the effectiveness of the hospital. So distributive justice would have a play as well. And of course, the stakeholders in these committee decisions, these P&T committee decisions, would certainly be the patients who are then or will in the future be in that hospital or being served by that Medicare Part D provider, the patients who would be served, in other words, by that organization. The prescribers certainly are stakeholders. Certainly the pharmacists are stakeholders as well, the pharmacists as well. And then the organization itself. The organization itself would be a stakeholder because they're going to be affected by the decisions of this P&T committee. Also, I think the healthcare system as a whole, because as you keep increasing the cost to the healthcare system, the whole healthcare system is affected. And then one other stakeholder would also be the pharmaceutical companies that are trying to get their products on these formularies. The issue of generic substitution, what we can say there is that the profession, which way back in decades past resisted the whole generic movement foolishly in many ways, but the profession now pretty much embraces the concept of generics and the benefits that accrue from that, mainly lower costs of drugs. And we're still in the fairly early stages of biosimilars. Now, biosimilars are, as you know, somewhat different from generics in that they don't have exactly the same structure. So they're sort of the chemical structure. So they're sort of between generic substitution and so-called therapeutic substitution, where you substitute something in the same therapeutic category but a different compound altogether. So they're sort of in between that. But gradually, pharmacists will be developing more facility with the interchange of these biosimilars, these very expensive drugs in most cases, but it's going to take a little bit of time for that to work out. Some of the ethical principles involved in the whole business of generic substitution would be certainly non-maleficence. Non-maleficence. You don't want to do harm to patients in recommending certain generics. Also veracity, explaining that the products are or are not going to be as effective as the brand name product. Distributive justice would be another principle. Another principle that would be involved here would be autonomy of the prescribers. Who might not feel comfortable either with the interchange of generics in rare cases, I would say today, but even more likely with biosimilars. So that would be a principle as well. And I think even you could even argue that another principle would be empathy for patients, where you're trying to save them some money, particularly patients who are having trouble affording a copay or don't have insurance and so forth. On page 2, it talks about therapeutic interchange, and you know that there, as we said, you're using a structure that's somewhat different from whereas in generic substitution, it's the exact same chemical that you're substituting. Here it's a different one. And as I said, biosimilars are technically would be in this category as well. Therapeutic interchange occurs widely in hospitals based on the P&T formulary, based on the formulary, where it's just automatic that in some cases you're going to have therapeutic interchange. In the outpatient setting, it's a little bit more difficult in that you have to get the explicit approval of the prescriber to be able to make an interchange of that sort. But here too, the stakeholders, I think, are pretty much the same as what we said with generics. Immunization, another factor in which we consider some ethical ideas related to communication and so forth. And here too, there's a requirement for pharmacists to utilize competence and veracity in encouraging patients to get immunizations which are in their interest, encouraging them to do it and having the competence to be able to administer it as well. While discussing in a truthful way without scaring the patient of any possible side effects. And immunizations, the use of immunizations effectively lowers healthcare costs overall. It clearly lowers healthcare costs because it prevents people from getting diseases which are going to be a lot more expensive. And fortunately, we see a lot of acceptance of patients being able to willing to accept the pharmacist's role in providing these immunizations. So we see this expanding. For example, now many of the pharmacists are explaining to people in their 50s, 60s, and so forth about the need to get probably 2 immunizations of the new vaccine to prevent shingles. There's a new one replacing the older one, which is much, much more effective. And even people who have had the older one have to get this newer one, and so pharmacists are in the job of explaining all of that. Collaborative practice medication therapy management, collaborative MTM is something we've discussed before, but it's just another area where this is important, both with regard to ethics and communication. So we mentioned these trends in terms of the rulings of state Supreme Court judges and federal judges regarding whether pharmacists have an expanded duty beyond just, as in the past, getting the right pills in the bottle and the right drug. Up until, it says, 1985, the only thing that was required was technical accuracy in dispensing. That was the only standard in court cases. If the pharmacist dispensed the right drug in the bottle that the doctor prescribed, it didn't matter if the drug killed the patient or wasn't the right drug or whatever. It's the doctor's problem. It's changed somewhat since then. So it says since 1985, special situations or circumstances that result in an expanded duty that pharmacists have to patients are represented by these so-called 8 exceptions. And these 8 exceptions would be reasons for an expanded duty beyond just getting the right pills in the bottle. The trend is in the direction of honoring these exceptions. We'll say, in this case, because of this exception, the pharmacist has an expanded duty. So let's look at those expanded responsibilities beyond the old rule of no generalized responsibility to warn. One is if there's an obvious error. So if the drug is obviously inappropriate, it's the wrong drug for the patient based on the patient's needs, their diagnosis, if you know it, or whatever it is, or if it's an obviously wrong dose, the dose is obviously wrong, that would be a reason for expanded duties of why you can't just say, well, you dispensed what the doctor prescribed. It would go beyond that. Also, if the pharmacist has, and I've emphasized the words knowledge here, of allergies. So if the pharmacist knows that a patient has an allergy based on the patient's medication record, or the patient tells them, like I think we had a case where the patient's surrogate said that the patient was allergic to NSAIDs or something like that. If the pharmacist has access to that knowledge, then you have the expanded duty. And this points out the curious thing that while it's ethically valid and required, actually, for us to try to have this expanded knowledge and to keep appropriate records and all that, it actually puts you at more risk for liability in a lawsuit than not. So it's kind of an interesting contradiction in a way. Similarly, knowledge of conflicting drug use. And that means if the pharmacist has knowledge of harmful DDIs, that information pops up on the computer processing system, the alerts that you get on the computer, that sets up the pharmacist for this expanded duty. And so in a court case, a litigant's lawyer can subpoena access to that medication system, the prescription processing system, and see if in fact that drug interaction pops up on their alerts. And if it does, then the pharmacist is at greater liability. But to say that, a way to solve this is we don't want to see any of these alerts, that would be totally unethical, so that would be inappropriate as well. The fourth exception is the provision of patient education or counseling. And so what this means is that when you counsel a patient, it better be correct. The information you're giving them has to be correct and appropriate. And if it isn't, you're setting yourself up for more of this legal liability in terms of an expanded duty. But as we know, if you want to say, well, the way around that is not to counsel at all, that incurs problems as well, legal problems and certainly ethical problems. So ethically, we certainly would use that argument. The fifth one is representations to the public in terms of advertising. So if a pharmacy or a chain, and many of the chains have ads like this, that our pharmacist is well equipped to advise you about these things and to detect errors and all that, that creates a reasonable expectation that you're going to do this, and it would also create an expanded responsibility for the pharmacists. Contraindications. So this refers to if the drug is, for example, a REMS drug, and there's clearly contraindications associated with that drug, risks as expressed in the REMS program, that sets up the pharmacist for an expanded duty. Withdrawn drugs. If a pharmacist, and I don't think this would occur, but if a pharmacist were, careless enough to supply a patient with a drug that had been formally withdrawn from the market, that would create this expanded responsibility in a court case. And same with mandated medication guides. Failure to provide the mandated medication guides, which is pretty much a requirement in the outpatient setting, would be a reason for these expanded responsibilities. So you can see the conclusion is, and I'll just read it, it says, although the foundational rule of no generalized duty continues to be the law, not the ethical imperative, in most jurisdictions, the exception to that rule, as referenced by these 8 exceptions that we just listed, for specialized circumstances, have caused the applicability of the foundational rule to change so dramatically that pharmacists are now held to a much higher standard than before, even when there are no allegations of order processing inaccuracies or dispensing errors, in other words, the old requirements. So what are some factors that influence court decisions, especially judicial decisions, about a pharmacist having expanded duty or duty to warn? A study was done 8 years ago, and these percentages are based on 8 years, so I'll explain how they've changed, no doubt, in the intervening 8 years. The decisions were based on these items here, 1, 2, and 3 on the next page and so forth. So one is pragmatism. And this study was done 8 years ago. 33% of judicial decisions were based on the idea that do the benefits from the expanded duty justify the cost of providing these duties? And a lot of times judges would say, we don't think that the additional costs involved in pharmacists doing all these new things is justified. 33% of the cases were based on that 8 years ago. Today, that figure 8 years later would clearly be lower. It would be significantly lower. We don't know exactly what that number would be, but it would be significantly lower than 33% of cases using that argument. Another one that was very popular back then was this command and control, or as it's called, excessive interference. And 43% of the cases were based on this 8 years ago, and this figure, it will be a lot lower now. And it was based on the idea that is an expanded role for the pharmacist likely to interfere with the well-established and revered doctor-patient relationship. And this is sort of the basis of that argument that we mentioned called the learned intermediary defense, the learned intermediary defense. The learned intermediary in this whole deal of prescriptions is the prescriber, not the pharmacist. That's what the old idea was. But increasingly, this is not being upheld in court. The pharmacist is not just an innocent bystander, but is also, in a different way, a learned intermediary who has responsibilities. The third basis for these court decisions, which was only 7% 8 years ago, but would be significantly higher today. If this study were done today, it would be significantly higher, referred to as the moral hazard. And this argument says, pharmacists are not, this court argument would say, pharmacists are not mere bystanders in the drug therapy decision-making process, but active participants when they fill prescriptions. So this is more in sync with what our idea of the current role and responsibilities of pharmacists would be. As I said, this percent would be much higher. And then the final basis of these court decisions was the one called professional responsibility, 17% 8 years ago. It would also be significantly higher today than 17%. And it's based on the idea that pharmacists have knowledge and skills which can improve the outcomes of drug therapy, and it would be foolish. It would put patients at a moral hazard not to use that. And of course, it's no secret that now the educational process for pharmacists is a minimum of 6 years, and the PharmD degree and the kind of clinical emphasis of these programs. So to say that we're not going to take advantage of this that would be kind of ridiculous. So you can see the trend in that direction. The summary is summarized there. I'll let you read it, and I think we've already said it, that where it says the bottom line, the trend line is gradually moving in the direction of court decisions, indicating that the pharmacist's role goes beyond just accurately dispensing the medication that is prescribed. So the next question here says, how effective are computer printouts and medication guides as a form of communication with patients? Well, first of all, it depends on the patient. So for some patients, they're more effective than others. Some don't bother to read it. Some may try to read it and either not understand it and sort of just ignore it, or some might read it and get excessively frightened by it and not use the medication. So you have all those variations. But research proves that these printed documents, whether they're the med guides mandated by REMS or the printouts that are available in most prescriptions in the pharmacies, that they're more effective if they're accompanied with some verbal communication, either from the physician or from the pharmacist, more likely the pharmacist. So that points out to the importance of that. And the practical formula for effective communication is summarized there, and I don't think I'm going to go through those issues, but you've heard them in your communication courses: reinforcement, augmentation, clarification. Just saying if you really want to add a few comments, to what the doctor said, things like that. Validating that the patient understands it, and using judicious and simple and clear terminology. Some ethical concerns regarding prescription drug advertising. And this applies to both professional advertising to doctors and pharmacists and nurses and others, as well as the direct-to-consumer, the DTC or direct-to-consumer ads that exist in our country and really very, very few other countries. Hardly any country allows those DTC ads. I don't know if that's good or bad, but that's the way it is. I think there's 1 or 2 other countries that do, in addition to the United States. Some of the issues involved here involve veracity. So the ads have to have full disclosure. They have to full disclosure. And this full disclosure facilitates the autonomy of prescribers, of pharmacists, and of patients, of all of those. So full disclosure can add to the autonomy of all those individuals, especially with the direct-to-consumer ads in terms of patients. And there are arguments pro and con with regard to direct-to-consumer ads. The argument in favor of direct-to-consumer ads is that it gives more information to patients and encourages their more active involvement in their own care. So it can, especially for patients who really can understand some of this stuff and interpret it, it gives them a better way to have active involvement in their care, which is a good thing. The con arguments are that it can lead to overuse of more expensive drugs. It can lead to overuse of more expensive drugs. You'll notice that they don't advertise generic drugs in these DTC ads. So that's a concern. And some feel that it can interfere with the autonomy of prescribers. That's probably sort of a self-serving concern, but that's a concern too. The bottom line is that pharmacists can really serve as a very valuable, unbiased source of information to consumers who have questions about these direct-to-consumer ads. The bottom says ethical issues regarding to the listing, posting, and advertising of prescription drugs. We've discussed before that while this was once regarded as unprofessional, today you have to list, have it available. You have to have available a list of the 150 most commonly prescribed drugs in your pharmacy. And some would say, well, this is less of a relevant concern today because people, 90% of people have their drugs covered by insurance. But increasingly with the very expensive drugs, people are faced with increasing out-of-pocket costs for the co-pays. For example, with the Medicare Part D drugs, the co-pays are usually, depending on what provider you have, about 25%. So as the overall cost of the drugs go up, it becomes an issue for patients. So it could be somewhat of a concern. On the last page, it talks about challenges faced by pharmacists in achieving effective communication with patients. And I think we can go through this kind of quickly. Access to patients' medical information. This is not an issue in hospitals at all, or or in ambulatory care medical clinics. And by the way, the number of jobs for pharmacists in these ambulatory care clinics and doctor's offices and things like that is growing considerably. Actually, that's becoming an increasing source of jobs for pharmacists. But in those facilities, you have access to the patient's medication records. In community pharmacies, where you don't have direct access to the patient's medical records, we explain to you ways that you can get that information from the patient if you need it. Physical barriers, the modern design of pharmacists really make the pharmacist more visible to the patient. And in terms of privacy, we know that modern pharmacy design has counseling bays and counseling windows and even private counseling rooms, so we're overcoming some of these issues. In terms of language barriers, if a large number of patients who use a pharmacy speak a language other than English, ethically, it's certainly appropriate, ethically, that you would have somebody there, a pharmacist or a technician or just an employee, who could serve as an interpreter of that language, rather than just saying, too bad, that all of these people speak language X and we don't speak it, that's not appropriate. Now, you can't obviously have somebody available for every possible language in a diverse area like ours, but there has to be some effort in that regard. And of course, many of the prescription processing systems are quite able, as you know, to print out labels in a whole variety of foreign languages. Then it talks about, let's see here, insufficient motivation and inadequate skills on the part of pharmacists. This would go against our code of ethics, because the code of ethics says that it's necessary for the pharmacists to maintain technical and update their skills, and so there's no real excuse ethically for that to occur. The duty to warn is as an aspect of informed consent. I think the ethical requirement for duty to warn is based on the principles, ethical requirement is based on the principles of autonomy, of beneficence and non-maleficence, veracity and competence. So full disclosure is necessary, but it has to be done in a way not to scare patients. Pharmacist counseling as an evolving standard in practice of pharmacists. Court rulings since 1970 As I mentioned, the trend lines are clearly in the direction of an expanded duty to warn. But even if a court decision is that you don't have the expanded duty, ethically you do. Ethically you do have the duty, and that's confirmed in our code of ethics as well. The quote professional practice standard. As more pharmacists try to implement the patient care model, as more pharmacists are using a patient care and clinical model and direct patient care model, this becomes the professional standard. It is today the professional standard. And so this could apply in court. In court cases, it could be brought up that this is the current professional standard to do these things, and that's why the trend is in the direction that we mentioned, but there obviously is still variability in court decisions. The objective disclosure standard, what this is all about, is that it means that the pharmacist can exercise professional judgment in how far the patient needs to go, in providing ADR information, that the pharmacist has the right to exercise professional judgment in doing that. And we have a case today, it's actually case 27, that illustrates this point quite well. So when we get to case 27, you might want to think about that. The reasonable person standard, what would a reasonable pharmacist do? This is similar to the professional practice standard that we cited up above there that could be used in court cases. What would a reasonable pharmacist do? And finally on this outline, it talks about the over 90 requirements in New Jersey. So I'd like to summarize the actual requirements in New Jersey of over 90 relating to counseling and so forth. So the first point in the over 90 New Jersey requirements we want to review is that you have to maintain a patient profile. You have to maintain a patient profile. That profile should include, obviously, the patient's name, the patient's DOB, date of birth, contact information, their email or home address or phone number, whatever contact information you have. Medications dispensed. Medications dispensed have to be added to that. And the date prescribed, in other words, the date of issue of that prescription, the date of issue when it was prescribed. And then the fill dates, the original fill date and any refill dates have to be on there. Also, if you have the information, it should include patient allergies, and any pharmacist comments, And the one thing I did mention, you obviously have to also have the name of the prescriber. The name of the prescriber has to be there. So the patient profile has a lot of information. The second point is that you have to perform prospective DUR on new prescriptions. Prospective DUR has to be performed on new prescriptions. And it should involve reference to the patient profile. It should involve reference to the patient's drug profile that you have. And that DUR should include DDIs, any researching of drug-drug interactions, as well as adverse effects, the major adverse effects. And on refills, under or over utilization, The third point is that on new prescriptions, there has to be a reasonable effort to counsel the patient. That doesn't mean you have to force the patient, but there should be a reasonable effort made, whatever that means. And that counseling should certainly include the nature of the drug, the dose, and how to use it. The nature of the drug, the dose, and how to use it. And relevant ADRs, and we've discussed, the issue of ADRs. It should also advise the patient how to sort of monitor, self-monitor the outcomes of the medication. The fourth point is that if the patient is not present, like mail order, if the patient is not physically present, the offer to counsel can be done in writing. and even in other situations in writing. The fifth point is that in refills you need to monitor utilization. You have to monitor if the utilization is appropriate. And then finally, the over 90 requirements do not apply to hospitals or nursing home settings. They do not formally apply to hospitals and nursing home settings. It doesn't mean that hospitals don't do some of these things, but these regulations don't specifically apply. So we're going to look at the last outline which I've given out, ethics of distributive justice and allocation of limited health care resources. And we won't finish this today, but you'll remember that because of the problems with the snow days and all that, that for Wednesday when we have our exam, and I'll admit, ethics exams should be a good thinking process for you, because we've covered a lot of ideas here actually. Don't be frightened by it. You guys are all very smart. You'll be able to handle it quite well, and we will be very careful in grading if we want this exam to up your grades and, of course, not lower them. But because I won't finish this outline today, we will use the very first part of the period next time to finish what I don't cover on this outline today. We won't have new cases. We will not have any new cases next time. And we'll certainly start the exam by no later than 10 minutes of 6. So we'll start the exam no later than that, hopefully even before. So let's see if we can cover some of the information, the remaining time we have today before we get into our cases, on this last outline dealing with distributive justice and the allocation of limited health resources. And all health resources are limited. So it says distributive justice requires fairness in the allocation of health care resources. It is a fundamental ethical value. And as we said, all health care resources are limited to some extent. Now, in our area, distributive justice even plays a greater importance than it does for physicians or others, because we deal with products, with pharmaceutical products as well as pharmaceutical services. So this distributive justice is an important ethical principle for us to worry about. It's certainly a newer principle compared to Hippocrates. And it says, importantly, distributive justice does not require that everyone gets equal access to health care resources. You can use different criteria as to who gets the resources. They don't all have to be equal. They have to be fair. They all have to be fair, but not necessarily equal. One consideration, for example, is who has the greater need. So that would be one consideration, but not the only consideration. Even, ability to pay, all those things would be considerations that would be justified in considering. Public perception of the pharmaceutical industry as a source of supply, since they're the ones who supply most of the pharmaceuticals. There's changing perceptions, and what that means is that up until maybe a decade or 2 decades ago, the pharmaceutical industry was so highly respected, almost, glorified and worshipped and so forth. But it's no longer true. It's still respected. It's still a respected industry. But since the 1980s, that level of respect is not as high and uncompromising as it used to be. And some of the reasons will be mentioned here. One of the outcomes of that somewhat diminishing perception of the pharmaceutical industry was that the APHA changed its name from what it had been since 1852, the American Pharmaceutical Association, to the American Pharmacists Association, because they wanted to point out to the public that we're not the organization that represents the pharmaceutical industry. We represent pharmacists in their practitioner and other professional roles. The other thing is that in recent years, because of the tragedies that have occurred with some of the irresponsible compounding pharmacies, particularly with regard to providing sterile products, legally there has been a clear delineation between the term pharmaceutical manufacturing and compounding pharmacies. And it's brought in the idea of outsourcing facilities, which are sort of in between a compounding pharmacy and a manufacturer like the pharmaceutical industry. So you have different rules for all of those areas. So that kind of distinction is being made as well. What were some of the reasons for some negative perceptions of the pharmaceutical industry? Well, we can see them there. We're familiar with all of them. The perception that branded prescription drugs are too expensive, and inordinate price increases of older drugs, generic drugs like EpiPen and things like that. Two, the perception of excess profitability of big pharma companies. And it's true that the pharmaceutical industry has been very profitable industry, more so than most other industries over the years. That's a little bit less today because of the influence of managed care and generics and things like that, but it's still a profitable industry. Concerns about excessively aggressive and unethical marketing tactics. You know, they were giving free trips to all kind of wonderful places for physicians who would prescribe their drugs. Some of that still goes on, but it's much more controlled than it used to be. Excessive lobbying that led, for example, to the government's inability to negotiate prices for Medicare Part D drugs in Obamacare. The pharmaceutical industry is one of the most powerful lobbying agencies in the country. The only two that I've read about that beat it are the American Medical Association, who also have a very powerful lobby, and you've also, I'm sure, heard of the National Rifle Association as well. But with those exceptions that beat out the pharmaceutical industry in their lobbying power, the pharmaceutical industry has been pretty good as well at effective lobbying, and that's raised concerns with some people. 5, the lack of full disclosure of unfavorable clinical trial data. Some highly publicized cases. A few years ago, there was the drug Vioxx, which was a very widely prescribed COX-2 inhibitor, and they had to withdraw it. They showed that they hadn't really fully revealed some of the adverse effects and so forth. Shortages of critical drugs, which is a big problem right now, which is diminishing some of the use of the pharmaceutical industry global, not just the research companies, but also the generic companies. Tactics to delay the entry of generics that companies have used. Some companies have attempted to transfer their headquarters to foreign countries for a tax advantage. That hasn't worked out so well because there's been a lot of adverse publicity associated with it, so I don't think that's occurred too much. But there have been some efforts in that regard. Pfizer, I think, a few years ago was trying to transfer their world headquarters from the United States to New York City, actually, to Ireland, and I don't think they were able to do it ultimately because there was a lot of pushback from the government. Specific reasons for positive perceptions of the pharmaceutical industry. They certainly come up with some impressive breakthroughs. We all know that. It's a desirable industry to keep or to attract to a state. And we have a lot of efforts from many, many states trying to attract companies in New Jersey to go to their other states where they have lower taxes and other benefits. And some of that has worked. Some companies have moved out of the states. A lot have moved up to Boston and places like that. But in general, the companies have provided a safe and adequate supply of drugs historically, although the persistent shortages at present are detracting from that. And in 2017, the Generic Pharmaceutical Association changed its name to the Association for Accessible Medicines. And this points out to the concerns that exist for drugs being accessible, meaning not being so costly that people can't afford them. The pharmacist's reactions to the public's changing perceptions of the pharmaceutical industry is dealing with the public attitude toward prescription prices. Now, I think there are some patients who sort of put some of the blame on pharmacists. But I think most people are intelligent enough to know that it's not the pharmacist who's dispensing these medications who's making the big profits, that it's really the companies there. So pharmacists have sort of isolated themselves, I think, from this public animosity about prices. But you're sort of on the firing line, so you get some of that. And then pharmacists, as we say, no longer resist generics. Ethical perspectives of specific drug supply, availability, and allocation issues. Generic substitutions and biosimilar interchange, clearly these represent pharmacists' ethical responsibilities. On page 2, it talks about the ethical principles involved in generic and therapeutic substitution. I think we've gone over these ethical principles involved in generic and therapeutic substitution, but let me just summarize them once again, just to be sure we all are on the same page here. Veracity. About, are these drugs as effective or as the brand name or not? Patient and physician autonomy. Patient and physician autonomy. Most physicians don't resist generics anymore, but there could be some physicians who do that. And every once in a while you run into a patient who absolutely doesn't want a generic, so you have to respect that. Distributive justice. Distributive justice. Competence on the part of the pharmacist to make the decisions. Competence. Empathy. Empathy for and compassion for the cost of drugs. That patients have to deal with the cost of drugs. And of course, non-maleficence, that you don't want to give a generic that's not going to work. You don't want to give a generic that's not going to work. So those are the clear ethical principles involved there. Therapeutic substitution, we've already explained there, and it's summarized for you, so I don't think we need to say any more about that. Counterfeit drugs. Counterfeit drugs are obviously illegal and unethical. They are obviously illegal and unethical. And the ethical principles involved there are veracity, trying to have a drug counterfeit. You're lying, to the patient that it's the real thing, so veracity. And also non-maleficence. Non-maleficence because some of these counterfeit drugs are harmful to the patient. A more general title that the government is using in this item down below there, where you see the item that is the specific law called the Drug Quality and Security Act. The Drug Quality and Security Act, which comes under the overall umbrella of the Drug Supply Chain Security Act, but here it's specifically the Drug Quality and Security Act. They use the term illegitimate product. Instead of the term counterfeit drug, they use the term illegitimate product. An illegitimate product would include counterfeit drugs. It would actually include counterfeit drugs. But it would also include, in this title of illegitimate products, in this Drug Quality and Security Act, this federal law, it would also include things like diverted products. Diverted products would be included in that as well. Diverted products, not just counterfeit products. Stolen products. Any adulterated product, any product that's been adulterated. So they would be included in that. Products obtained through fraudulent transactions. Products obtained through fraudulent transactions would be included in that. So in general, any product that's likely to be harmful, that has the potential to be harmful to patients, that would make it unfit for distribution. In this Drug Quality and Security Act, we want to talk about some of the factors involved in this federal legislation. Is Dr. Kuzmov here yet? Because I do want to break off and do the cases, but I guess he's probably, they're talking. He's coming in right now. So, okay. All right. We welcome Dr. Kuzmov, and who's going to go through the cases here. So let me just finish this summary of this Drug Quality and Security Act, some of the factors involved. It's been in effect since 2015. It has been in effect since 2015. What it requires is that you have paper or more likely electronic documentation, to show the history of the pharmaceuticals that you dispense, the history. In other words, that they were obtained through legitimate sources. And you have to maintain those records. At least they have to be, you have to be able to access them for a period of 6 years. So those are some of the issues where you have obtained them. So basically that means, for example, having the bill or the invoice or a record or some kind of a record from the wholesaler, from the wholesale distributor where you got it. You have to maintain that. And this can be done in a variety of ways. In big corporations, I think it's sort of done automatically. But in the case of a recall, for example, you have to be able to access that information quickly. And it's to prevent these illegitimate products, including counterfeits. It's basically to prevent. This has sometimes been referred to by the term track and trace legislation, track and trace. So if you hear that term, it refers to that. And finally, 90% of drugs are obtained through the three national wholesalers, the three large national wholesalers. You know what they are, I'm sure. Cardinal Health, AmerisourceBergen, and McKesson. And you know, if you're obtaining the products through those sources, you have probably less of a worry than if you're getting them from lesser known sources. So that talks about that. So we really don't have too much more to cover that we'll be able to do on Wednesday. And now Dr. Kusmov is going to call up the people who are going to do bioethics case number 26. So this is the remaining cases up to 30 cases. So let's have a volunteer read case 26.
Make a bet.
I'm probably going to go off. Very unlucky. I'm pretty sure I'm going to get called.
Okay, so for case 26, you have Regina Chen, Leah Johnson, Sung-Ki Kim, Hannah Lee, Zipping Lu, Andy Nguyen, and Medha Rao.
Let's put the fire's eyes.
Okay, who wants to read this case? You go? Okay, let's hear it.
Rhoda Shaw, a recent pharmacy graduate, was a pharmacist on duty on a hot summer afternoon at a busy independent community pharmacy in a congested downtown shopping area in a relatively large New Jersey city where there were always a lot of people visiting the various shops. Suddenly, a very concerned and excited lady, along with her young daughter, approached the pharmacy counter and shouted to the pharmacist that the child was having an asthma attack and didn't have her inhaler with her. She frantically told the pharmacist that she needed an albuterol inhaler. Rhoda asked if she had a prescription. The lady said no, but she had a prescription that was filled at a CVS pharmacy in her hometown, but she forgot to bring it with them today. Rhoda indicated that he could not give out a prescription medication.
Rhoda is she. So sorry about that. My fault.
Rhoda indicated that she could not give out a prescription medication without a prescription, but suggested that they go to the ER at a nearby hospital. The woman asked her to call 911 to send an ambulance. The ambulance arrived fairly quickly, took the child and her mother to the ER where the child was treated for the asthma attack. Although the child survived, she had to be hospitalized for a few days, and the physicians told the family that if a few more minutes had elapsed, the child would have died. The mother was very angry and filed a complaint against the pharmacy to the State Board of Pharmacy. Comment on the ethical implications of the pharmacist's actions in the situation. Would you have handled the case differently?
Okay, let's have some commentary.
So this is a tough situation because you had a chance to help them right then, but you didn't want to break the law, which I think was the right thing for the pharmacist to do. So I think the pharmacist made the right decision not to give it out and just to refer them to the emergency hospital.
I think that the pharmacist really underestimated her ability as a healthcare professional. I think we also learned that pharmacists can dispense emergency medications, especially if it's a chronic medication, for about like 72 hours. So if I was a pharmacist, just because it is a life-threatening indication, and she clearly sees that the child is having an asthma attack, I would have given at least maybe 1 or 2 day or max 3 days supply for the asthma indication.
So I agree with Hannah also. I think as a pharmacist, our duty to do no harm really comes into play in this situation. So I would have definitely given the inhaler, and then I would have transferred the prescription from CVS and documented everything.
In addition to what was said, I think perhaps more background information should have been collected by the pharmacist, because they could also be potentially confused with other like shortness of breath, maybe also confused with other emergency situations, so like allergic reaction or that need like other treatment.
So I definitely would call 911 first, and maybe an alternative would be to call the CVS that the girl gets her prescription filled at, and if I could get a verbal, like if the pharmacist can confirm that she is on the medication, I would feel more comfortable giving it to her. But there's the possibility that I might be put on hold. In that case, I guess the ambulance would be coming, but it is a tough situation.
Yeah, I also agree. It involves a like tough situation that as the previous colleague said that she should yeah first and also what is it call to CVS for a more patient profile so that like the pharmacist and the can manage better of the patients.
Okay, so I think it's apparent that we have somewhat of a differences of opinion up here, which is understandable. This is kind of a difficult case. I'll give you my summary reactions for what it's worth. I think you were correct in indicating that the pharmacist should try to confirm that it's an emergency situation with the potential of loss of life, because a severe asthma attack can very quickly lead to loss of life. But I would try to assess the patient as best you could to see if this in fact does seem to be a serious situation. The mother, the child is there, and so forth. In my opinion, which could be challenged certainly, and not the only valid opinion here, I would probably have given the rescue inhaler because time is of the essence here, and if the child had died because of the asthma attack without the inhaler, I think that would be the more serious outcome. Certainly contacting CVS is necessary, appropriate, and as you indicated, though, you could be put on hold. You'd have to ask the mother if she knows which CVS it was. You'd have to then determine the phone number of that CVS. If the mother doesn't have it with her, which she probably doesn't. So all of that could be taking time in what could potentially be a life-threatening situation. Calling 911 is probably at the same time a good thing, but you don't know how long it's going to take for the ambulance to arrive, how long it'll take them to get the child to the emergency room. So I think you could justify giving the inhaler and then in due time contact CVS to verify that there is a valid prescription there. You'd want to also get the information of who the doctor was and so forth, so you could be in touch with the doctor and get the doctor's understanding of why you had to give this. As you know, there is a rule in New Jersey that you can give a 48-hour supply. Now, an inhaler is hard to break down into a 48-hour supply, but you'd give the inhaler, of course, as close as you could get to a 48-hour supply. But the complication here is that you don't have the prescription on file. You can do that when you have a prescription on file in your pharmacy, even though there's no refills left, you have it on file, but you don't have that here. It's apparently with CVS, which you'd have to verify. The ethical principles involved here, certainly non-maleficence for the patient. You don't want them to have a life-threatening asthma attack. Empathy for the situation that the mother and the child are going through. And competence on the part of the pharmacist, who would have to clearly validate, for protecting, for legal reasons, validate all the actions that were done and the information was available. The stakeholders, of course, would be the caregiver here, the mother, the patient herself, the patient, the pharmacy owner. The pharmacy owner could be, in trouble here. The pharmacist, Rhoda in this case, and the profession as a whole. So I think that pretty much covers. Any other comments? Go ahead.
Does the Good Samaritan law apply in this situation?
Good Samaritan law apply in this situation. I think you could argue that, certainly. You could argue it, whether it would hold up if you're challenged in court or by the state board, I don't know. I think here, if you could document that in your professional judgment this was a life-threatening situation, it would be pretty hard for the state board or anybody to really, make a big deal out of it. This is not something where they need an opioid or anything like that. So, okay? Any other comments? Great. All right, let's move on to case 27, and we thank you, folks. We indicated that case 27 illustrated the idea of using your professional judgment in how far you have to go in talking about adverse effects.
All right, so for case 27, we have Emma Clausen, Alicia DeRosa, Jennifer Hahn, Yi-Rang Park, Richa Patel, Yasha Patel, and Reena Rai.
Not beneficence, not maleficence.
John Schonhart, a 49-year-old accountant, came to the pharmacy to pick up a prescription that his doctor had transmitted to the pharmacy for a tricyclic antidepressant to treat his depression. John had just gone through a difficult divorce, and he was especially upset that he had become alienated from his teenage son. He was also having a rough time at the accounting firm where he worked, and he was afraid that his position was going to be eliminated. The pharmacy tech gave John the prescription and asked if he had any questions. John indicated that he did, so the tech summoned the pharmacist, Hina Patel, to speak to Mr. Schonhart. The patient rather pointedly asked the pharmacist if the drug posed any dangers. Among other things, the pharmacist noted that the drug could pose some toxicity, especially if taken more frequently or in larger dosage than what was prescribed. A week and a half later, a police officer came to the pharmacy asking questions about Mr. Schonhart's prescription and indicated that the patient had ingested a large quantity of pills and died, the result of an apparent suicide. Upon hearing of the incident, Hina felt guilty and somewhat responsible. Could the pharmacist possibly have done anything differently that might have prevented this tragedy?
Okay, let's have your commentary.
To be honest, I think there are not many things we could have done to prevent this kind of incident because we have limited amount of time to counsel the patient, and I think it's pretty impossible to assess patients' suicide risk while we're busy going over side effects and contraindications and other important information we have to go over.
Yeah, I agree. It would be hard because the patient clearly asked for the danger, so they gave the danger. But maybe they could have give some positive effects of the drug.
I don't think she should feel responsible, but she could have mentioned some of the more frequent adverse reactions, like anticholinergic reactions of the tricyclic antidepressants. And also, he has a teenage son. I think it's important to mention the toxicities because his son has a handle on it. He could have done something similar.
I agree that the pharmacist shouldn't feel guilty for this because you never know what the patient is thinking. You never know that, you don't want to anticipate that they're going to use it for such a terrible purpose. But she also does have to warn for the danger of potential overdose because if she does it, then that could also be liability on her because she failed to warn the patient.
Yeah, I agree with what she said about the liability because if she didn't warn the patient and this would have happened, she would have felt guiltier than she feels right now. And I also think it's normal for her to feel the guilt because I can put myself in a situation and I think if something like that happened, I would have assessed how I counsel the patient. So I think it's okay, it's reasonable to feel the guilt. She's not responsible for what happened because it wasn't in her control.
Yeah, she's certainly not legally responsible. Nobody mentioned something that should be on our minds anytime we're dispensing antidepressant drugs, and especially if the patient is under a lot of stress like this patient seemed to be. Whether the pharmacist knew that or not is hard for us to know. But what is the one thing that wasn't mentioned by anybody here that clearly should be in mind when we're dispensing drugs for treating depression, antidepressant drugs?
Increases the risk of suicide.
Yeah, exactly. Suicidality. Suicidality should be on your mind. There's no easy way to prevent it, but you want to try, this is really hard to do, but you want to try to not make suggestions or to make statements that might be suggestive of the idea that, hey, I could use this for suicide. Tricyclic antidepressants in particular are a good candidate to use for suicide because once they're in the body, it's very hard to remove them, more difficult than for the SSRI or SNRI antidepressants. So the pharmacist maybe had, couldn't have prevented this, no doubt, but maybe should feel a little bit guilty about the fact that maybe she shouldn't have been so quick to point out how taking an overdose of this drug could really be very dangerous, because that might have been suggestive to somebody who's thinking about a way out, suicide is a way out for my problems, it might suggest to them that, hey, if you're looking for a way to do it, this might be the perfect way. Now, you know, so it's possible that what she said was suggestive. How she could have gotten around this when he asked if there were any side effects, I mean, I guess I would have maybe violated veracity and not talked so much about the fact that an overdose could, I wouldn't have mentioned an overdose at all, or you know, taking a large quantity or too large a dose. I would have sort of, you know, finessed it in some other way that these drugs are safe, try to follow the directions, these will really help you, you know, things like that. But ultimately, you know, obviously if this guy had in his mind to commit suicide, it's not the pharmacist, within the pharmacist's ability to totally prevent that, but you would want to be careful. So some of the difficulty, of course, a difficult case, some of the, but the pharmacist would be within her right to use her professional judgment to withhold data on adverse effects if, in her judgment, it could lead to a problem like this. So that's what I was referring to about, you know, exercising your judgment and how far you go with talking about adverse effects, depending on the patient, the situation, the type of drug, all of that. So the ethical principles involved here would certainly be non-maleficence where you want to prevent suicide, but at the same time veracity, you know, you want to make truthful statements as best you can. The empathy, certainly empathy would be a factor as well. The other thing here would be, remember the issues of consequentialism versus non-consequentialism. Here, I would sort of go with the idea of consequentialism, that by not mentioning the danger of an overdose, that if the outcome was that you're not going to end up with suicide, that would justify my not mentioning it. You know, that would sort of be my ethical thinking here. Maybe it's wrong, but that would be the way I would think of it. Competence might be an issue here too. Competence, maybe the pharmacist, you know, it's not clear that she was aware of you know, the potential dangers here. So, and maybe she didn't know that this guy had all these problems with his divorce and his son and all this kind of stuff. The stakeholders, I think, are obvious: the patient, the pharmacist, the doctor, probably the prescribing doctor here. The pharmacist owner would be, you know, at risk here as well if there's any lawsuit. It would be hard, though, to justify a lawsuit in this case, I think. So, thank you all, and interesting case. But let's go on to case 28.
Okay, so for case 28, we have John Choi, In Jung, Rebecca Kim, Mega Shah, Maloney Shah, Ridhi Virparia, and Enoch Yu.
Okay, if you're ready to start reading the case, it's okay to start. We're all